The Madlanga Commission of Inquiry has turned sharply towards the constitutional core of South Africa's justice system this week. Testimony from senior prosecutors and former police officials has laid bare repeated attempts to bend the national prosecuting authority and investigative arms to political will. What emerges is not merely a tale of individual misconduct but a direct challenge to the rule of law as entrenched in the Constitution. Section 179 of the Constitution places the prosecuting authority under the final responsibility of the National Director of Public Prosecutions. Yet it also demands independence from improper influence. Witnesses described phone calls from senior political figures demanding that certain dockets be parked, or that charges against connected individuals be withdrawn. One former senior prosecutor recounted being told that pursuing a high-profile corruption case would complicate the political landscape. Such interventions strike at the heart of prosecutorial discretion, which must rest on evidence and the law alone. The Commission has also heard how dockets were shifted between units or investigators reassigned when cases touched powerful interests. This pattern echoes the very practices the Zondo Commission exposed. Yet it persists. The Constitution's founding values in Section 1 demand a state founded on the rule of law, when those charged with upholding it instead receive instructions to shield allies. The separation of powers collapses into a facade. Courts can only adjudicate the matters placed before them. If prosecutors are compromised at source, judicial oversight becomes an empty ritual. Critics of the inquiry argue that exposing these pressures risks demoralizing officials and handing ammunition to those who already dismiss state institutions as captured. That concern carries weight. Public trust is fragile, and selective leaks could be weaponized. Yet the alternative, allowing political interference to continue unchecked, is worse. The rule of law does not survive by shielding uncomfortable facts. It survives through consistent application of principle, regardless of who stands to lose. Constitutional Court precedent has repeatedly stressed that the NPA must operate without fear or favor. In decisions stretching from the Glenister judgments to more recent rulings on prosecutorial independence, the bench has warned that any perception of political control corrodes the legitimacy of the entire criminal justice chain. Testimony now before the Madlanga Commission suggests those warnings were not heeded. The question is no longer whether interference occurred, but whether the current constitutional architecture contains sufficient safeguards to prevent its recurrence. One witness proposed legislative amendments to insulate the NDPP's office more firmly, including fixed-term appointments insulated from ministerial whim and a clearer statutory bar on direct communication between politicians and prosecutors on active matters. These ideas deserve serious consideration. At the same time, structural fixes alone will not suffice if the political culture continues to treat the justice system as an extension of party discipline. The Commission's final report will need to address both the legal mechanisms and the underlying expectation that loyalty to the ruling party trumps loyalty to the Constitution. The stakes extend beyond any single case or individual. When prosecutors hesitate because of who the accused knows, ordinary citizens lose faith that the law applies equally. That loss of faith is the most corrosive threat to the rule of law. South Africa's constitutional project was built on the promise that no one stands above the law. The evidence emerging at the Madlanga Commission shows how close that promise has come to being broken. Restoring it requires more than fresh inquiries. It demands a political class willing to accept that independence sometimes means losing cases they would rather win.